Moments after a crash, a cheerful voice from the insurance company asks for a quick chat about what happened. What you may not know is that one careless sentence can help them put the blame on you and wipe your payout to zero under Texas law. Here is the exact wording that helps keep your money safe, starting with the safest reply when they ask you, "How are you feeling?" "Hi, I'm personal injury attorney Max the Axe, the gold standard in personal injury." And if you've been in a car accident in Texas, one of the first phone calls you're going to receive is going to be from an insurance adjuster. I want to be very clear from the jump on this. The adjuster is not your friend. They are not on your side, and it's their job to make sure that you get as little money as possible. So while they may seem very caring and friendly, please know it is their job and their interest to make sure that you do not get fair compensation for your injuries. And this means that you need to understand the best ways to protect yourself when you get a call from one of these adjusters. I'm going to walk you through exactly what these adjusters are looking for, what kind of questions they're going to be asking you, and most importantly, what is the best way to respond to them to make sure that you preserve your legal rights and your financial future if you've been injured in a crash. Keep in mind that the wrong answers in this phone call can cost you thousands or tens of thousands of dollars in the future. What insurance adjusters are really trying to do. Before we start talking about the specific questions, you need to understand what the adjuster's job is. Their performance at their job at the insurance company is measured by how little money they give out to injured people. How many settlements can they secure for as little money as possible? They have quotas, they have bonuses, and they have extremely advanced training on how to get you to say things that hurt your case. They're going to sound friendly. They're going to sound like they care for your well-being. They're going to say things like, "We just want to get this wrapped up quickly so you can be on your way." But please keep in mind what their job is. But here's what's really happening. They are building a file to minimize or deny your injury claim outright. In Texas, we follow what is called a modified comparative negligence standard. This is under Civil Practice and Remedies Code 33.003. What this means is that if you're found to be 51% at fault or more, you will recover $0 for your injuries. Even if you're just partially at fault, somewhere less than 50%, your damages get reduced by that percentage. So when the adjuster is asking you questions about what happened and getting into the nitty-gritty, what they're trying to do is to get you to accept some blame for what happened. First phone call strategy. Here's what I tell every client about this first phone call with the adjuster. You are under zero obligation to give a recorded statement to them. None whatsoever. They might say things to you like, "Oh, you have to cooperate," or "I can't move forward unless you give me the recorded statement." This is not true whatsoever when it comes to the other person's insurance company. Now, if it's your own insurance company, the rules are slightly different. You're still under no obligation to give a recorded statement immediately. You can always say, "Hey, I need a few days to get my thoughts together and to see how my injuries are doing. Let's just reschedule this for a week from now." And why does this matter? Because right after a car accident, you're often in shock. You might be in pain, on medication, or not able to think clearly about the crash. Anything that you say in this statement can and will be used against you later, even if you just forgot or misspoke during the statement. The most dangerous questions they ask. Let me walk through some of those specific questions that can destroy your case if you're not careful. The question, "How are you feeling?" seems innocent enough, right? That's what nice people do when they talk to each other, when they care about each other. And most people respond automatically with, "I'm fine," or "I'm doing all right, thank you." However, even those polite niceties are going to be used against you later to prove that you were never injured. Instead, you should say something like, "I'm currently being evaluated by my doctors," or "I'm going to follow up with medical treatment." When they say to you, "Tell me what happened," that's when they're trying to get you to accept fault. They want you to say things like, "I didn't see the other car," or "Maybe I could have been going a little bit fast," or "Yeah, I could have done things a little bit differently to avoid this." Don't speculate about what you could have done differently. That does not answer the question of who was at fault and who was negligent for causing the crash. Just stick to the basic facts. I was driving south on Main Street and the other driver ran a red light and hit me on my left side. They will always ask you, "Were you wearing your seatbelt?" In Texas, not wearing a seatbelt cannot be used against you to prove negligence under Texas Transportation Code 545413. However, not wearing a seatbelt can be used against you to argue that you contributed to your own injuries. If you weren't wearing a seatbelt, do not lie, but you do not have to volunteer information that will hurt you. They'll ask, had you been drinking? Or were you on the phone? These are the fault-building questions. Always answer honestly and directly, but you do not have to elaborate more than the question being asked. A simple no is sufficient. They'll ask you, do you think you'll need more medical treatment? This is a trap. If you say no, they will use it to argue that you were never really hurt. If you say yes, then they will try to get you to commit to a shorter treatment timeline. The correct answer is, I'm still being evaluated by my doctors. How to handle medical information requests. Adjusters love to ask about your medical history and your pre-existing conditions. They might say something like, have you ever hurt your back before? Or any prior accidents or injuries? Here's what you need to know. You don't have to volunteer your entire medical history over the phone. If you do have pre-existing conditions that are completely unrelated to the body parts injured in this crash, that's probably not going to affect your claim at all. But if you do have prior injuries to the exact same body parts complained about, that's something that they'll definitely want to know. The key is not to volunteer information and not to guess or speculate. If they ask you about prior medical treatment, it is completely fine to say, hey, let me get my old medical records together to give you the most accurate picture on that. Under Texas law, specifically in cases like Haygood versus D. Escobedo from our Texas Supreme Court, having a pre-existing condition does not bar you from recovery. If the accident aggravated or worsened your condition, you can absolutely recover for that. But you want to make sure that any discussion about prior medical issues is handled very carefully and only with the complete information. Questions about vehicle damage and speed. They're going to ask you about the visible property damage to your vehicle as well as how fast you were going. When it comes to vehicle damage, just stick to what was observed. You can say things like there was significant damage to the front left part of my vehicle or the airbags deployed. You don't need to exaggerate, but you don't need to minimize it either. Also, if you haven't had time to get a good look at it, you can say that as well. The questions about speed are a little tricky because most people are not looking at their odometer right before the impact happens. On this issue, do not guess or speculate. If you were going the flow of traffic, you can say that. If you don't remember exactly, saying that I was traveling at a speed that was safe for the conditions is 100% appropriate and way better than just guessing a specific number. The property damage settlement trap. Here's something that catches a lot of people off guard. The insurance adjuster might offer to fix your car first, separate from the injury claim. They might say something like, well, let's get your car taken care of first, and then we can worry about the injury part later. Be very careful here. Sometimes the document that you sign for the property damage also includes language like release of all claims or full and final release. Read everything very carefully, word for word. And if you see anything that says release of all claims, do not sign that document. You may be forfeiting your right to pursue an injury claim later. Be very careful here. Sometimes these documents that you sign also give up your rights to pursue an injury claim as well. Be careful with the words full and final release or release of all claims. If you see any language like that, do not sign the document without talking to an attorney first. What about independent medical examination? As your case progresses, the adjuster might ask you to see a doctor of their choosing in what is called an independent medical examination. Let me be clear on this. This is anything but independent, and they do not have an absolute right to demand this of you, especially early in the process. These things should actually be called defense medical examinations. The defense chooses the doctor always works with the defense, and wouldn't you know it, they seem to have the same opinions every time. And those opinions are that you're not really hurt, or that if you are hurt, it's caused by something else, not the crash. You generally don't have to agree to these kinds of examinations unless you're in litigation and the court orders it, or unless there's a specific policy provision that requires it. If they say that there is a provision, ask for it in writing. Recorded statements. What you need to know. If you do decide to give a recorded statement, here are the ground rules. You can have your attorney present for the call, you can ask for a copy after it's over, and you can take as many breaks as you want if you need to think about a question or if you're in pain. Keep your answers short and factual. Don't speculate about what other people were thinking or doing. Don't guess about speeds, distances, or timing if you are not 100% sure. Saying, I don't recall or I don't know are perfectly acceptable answers. If you realize that you made a mistake or you said something wrong, correct it immediately. You can say something like, "Hey, I need to clarify something that I said earlier," and then provide the full information in context. The settlement discussion trap. Eventually, the adjuster might start talking about settlement. They might throw out to you a low number and say something like, "Well, that should cover your medical bills and a little something extra for your trouble." This part is important. Do not accept any settlement offer unless you know the full extent of your injuries and damages. Many injuries do not show the full extent of the damage until later on. Many injuries, especially spinal injuries, don't show their full impact until later on. What feels like minor pain today that hopefully will go away in a few days could result in a permanent pain that you'll have to deal with for the rest of your life. If you're already feeling back to normal 100% just like right before the crash, then that's okay. But if you're still in pain, you have no idea how bad it's going to get or how long it's going to last. In Texas, once you settle your claim, you can't go back later on when you realize that the injuries were worse than you thought. Under Texas Civil Practice and Remedies Code 16.003, you generally have 2 years from the date of the incident to file a lawsuit for personal injuries. However, if you settle, you give up your right to file suit in the future. When you should stop talking to adjusters. If your injuries are anything more than very minor, or if the negligence is disputed as to who caused the crash, or if you're dealing with very high medical bills, that's when you should talk to an attorney about handling the communications between you and the insurance company. If your pain doesn't go away in the first few days, that's when you should call a lawyer to discuss the best path forward for you. If you hire an attorney, you are under no legal obligation to continue communicating with the other person's insurance company. Your attorney will handle all communications for you. In fact, once the insurance company knows that you have an attorney, they are not legally allowed to contact you to ask you any more questions. And hiring an attorney may protect you from saying things that hurt your case. Understanding bad faith in Texas. Insurance companies in Texas have a legal obligation to deal with you fairly and in good faith. Under Texas law, specifically the Deceptive Trade Practices Act, insurance companies cannot misrepresent their policy or delay payment. Under Texas case law, such as Stowers Furniture Company versus American Indemnity Insurance, insurance companies cannot deny reasonable demands that are made by your attorney. If an insurance adjuster is pressuring you to settle quickly, or misrepresenting their policy, or demanding information from you that you don't have to provide, this could be an act of bad faith. Document these interactions and consider talking to your attorney about this. Remember, you have rights in this process. You have the right to be treated fairly by the insurance company. You have the right to have your case fairly investigated. You have the right to seek medical treatment from whichever doctor you prefer. And you also have the right to legal representation. Don't let an insurance adjuster make you feel like you're asking for too much or you're being unreasonable. Their job is to pay you as little as possible. Your job is to make sure that you are fully compensated for all of your damages, protecting your future. The decisions that you make in the first few weeks after an accident could affect you for the rest of your life. Don't feel the pressure of just needing to get it over with impact your ability to get exactly what you deserve. I have personally talked to dozens of potential clients who I could not help because they had already signed a contract with the insurance company when they had significant injuries. In one such case, a woman got into a crash and had knee pain. She accepted $3,000 from the insurance company, but then she later needed to have knee surgery, and that knee pain is going to affect her for the rest of her life. Now that $3,000 is all that she could recover from the insurance company. Cases like that are a tragedy. Don't let the insurance company pressure you into accepting anything less than what's fair. Take the time to understand your injuries. If you have not healed 100%, think twice before accepting any offer. Follow up with appropriate medical care. Document everything. And of course, please talk to a lawyer if you're unsure how to deal with insurance companies or you don't even want to deal with them anymore. What we've covered here today is just the beginning of how to protect yourself after a car accident. You now know how to handle those initial adjuster conversations, what questions are going to be asked, and how to avoid those big traps that can seriously hurt your case. But there's another critical decision that can make or break your case, and that's knowing when to follow up with medical treatment. Most people think that they should wait to see if the pain gets better on its own, or they're worried about the medical bills and who's going to pay. Those delays can seriously damage both your health and your personal injury case. In my next video, when should you see a doctor after a Texas car accident? I'm going to walk you through exactly that. when you need medical attention, how delays in treatment can hurt your case, and what to do about the bills while your case is pending. This is not just about your legal case. This is about protecting your health and making sure that you don't have to pay for somebody else's mistake. I'll see you over there.